In today's video, we're going to talk about the responsibilities of attorneys who are coming after you with debt collection letters, who are authorizing their companies to put debt collection trade lines, negative trade lines on your credit reports, and also to sue you in court without proper documentation. This is very important. Please like this video. Please share this video after you finish watching it. This is very important. We are seeing tons of cases across the United States where debt collectors are filing either debt collection notices without all of the documentation, or they are also filing court cases without all of the documentation to prove what they are claiming in court. So you may be asking, Steve, how are they able to do all of this stuff and get away with it? You might be asking, Steve, I sent them a debt validation and they sent back some documentation. Why are they able to get away with it? The reason why they're able to get away with it is because you're not asking the right questions. You are not asking the right questions. You are in the ballpark. You're in the game when you send a debt validation, but you're not putting them on record to make sure that they're going to verify everything that they're claiming. Until you ask the questions the right way, they can skirt the laws. And you don't have to take my word on it. You can just see what is being done out there. Prime example, I have an email here. Gentleman from Texas sent me an email this morning, and he stated that he is getting sued. As of last week, he got a lawsuit in the mail for $4,000. He says that he knows from his recollection that the total amount would only be, if that, would be about $2,000. And he said that he even has documentation to prove that it is not $4,000, that it is actually $2,000 or maybe even less. He even went as far as to look up cases in his state where it stated what a debt collection attorney has to prove to be able to bring a case and the amounts. And just like I just said earlier, is that most people are in the ballpark, but how are you going to construct the information that you saw from another case, the information that you've seen and heard, all of these different tidbits about how you can respond to debt collection lawsuits, how you can respond to debt collection letters? How are you going to compile all of that information together and get the debt collection attorney to take you serious about what you are actually saying? So first, let me share with you what could happen to a debt collection attorney if they are shown to have violated your rights by either misstating amounts that they claim you owe, by either not providing documentation or providing false documentation. Let me tell you what could happen to them, and then I want you to run through your mind of the things that you've heard or the things that have happened to you or debt collection letters that you have received that you know are not true, and that you've potentially sent a debt validation letter to them knowing that the information that they sent to you was false. And with you knowing that it's false and they knowing that it's potentially false, why are they not afraid of continuing to do what they do to people? So first, let's go over what they could be risking. So if a debt collection lawyer submits claims, when they say claims, or it could be anything about the case, but also the amount that they're claiming that the person owes, or documents that they don't have or cannot verify, they risk sanctions and legal consequences. Courts can impose penalties, fines, or even dismiss the case against the lawyers who knowingly submit unverified or false information. This helps ensure that only truthful, verified evidence is presented. Of all of the people who come to us who have used other services that are out there, and even some that have used attorneys to represent them in court against other debt collection attorneys, I would say the number one thing that they never did even attack with the attorney was the documentation and the claims, the claimed amount that they claimed that they owed. It was always veered over to, let's look at doing something to settle this account. And I believe that people move into that settlement right away when it's attorneys against attorneys is because they're in the mindset of resolving everything, both sides come to some agreement. But if you are of the mindset where you're like, I know that this is not right. Yeah, I used to have that account with that other company, but I know that this information that they are presenting here is not right. And so and you might even know what laws with the Fair Debt Collection Practices Act that you could even state in there. But the problem is that if you don't put that puzzle together the right way, it's going to be disregarded. And you know that it could be disregarded because just like the gentleman who emailed me and other people who have emailed or who have put comments here on YouTube or on other platforms, they state that they sent them a debt validation and everything was disregarded. And then they ended up going into court and nothing was proven and it was disregarded. The reason why it's disregarded is because the way that you responded to your case or the way that you responded to the debt collection letter gave them permission to not have to do what they are required to do. Also, an attorney who submits claims or documents and they do not have or cannot verify, they also risk ethics violations. Lawyers are bound by state bar associations ethics rules, which can lead to disciplinary actions, including suspension or disbarment if they misrepresent facts or submit false documents. They can also risk by fraudulently misrepresenting submitted claims or documents that they know to be untrue can amount to fraud. In this case, debtors can file complaints or countersuits, which can lead to legal consequences beyond the immediate case. The consumer protection violations under the Fair Debt Collection Practices Act, a debt collection lawyer must provide accurate and verified information when collecting debts. Violations can result in FDCPA, Fair Debt Collection Practices Act, claims, damages, and additional legal liability. Ultimately, the debt collection lawyer's responsibility to verify claims protects both the debtor's rights and the integrity of the legal system. If a lawyer knowingly lies or fails to verify claims, they undermine the system and risk significant consequences. So with that being said, how do we get this action to actually manifest when we're dealing with debt collection letters and when we're dealing with debt collection lawsuits? What we have to do is, number one, and my mind is racing, so I'm going to be thinking through this, because what I'm doing is I'm reaching into my experience with dealing with clients, and I want to pick one. I'm going to pick this one. This is a big one. And I'm going to put the dismissal uh, uh, document here on this video. This is all right. So I just went and opened up the document here for the response, and the things that really, this was one that was $100,000 and some change. It was 100 some $1,000, and it was purchased by a debt collector. And looking at the way that this challenge was put together, so just like I said earlier, is that we want to challenge the debt collection attorney for the documents that they're submitting to the court, because what they're going to always have to do is they're going to have to go to their client to get documentation and then verify those documents, and they can't come back and say that those documents are 100% accurate if they cannot show how they determine that they're accurate. Now, that could leave a little bit of a gray area, and that's going to go back for you to be able to challenge. You have to ask the questions the right way to get them to give you the answer that you're looking for, to make sure that they're actually verifying that they're not just kind of skirting the law. So with this particular case, this case actually took more than a year. It shows here that it was 2022. It took about a year and a half before the debt collector gave up. And now you know why it's going to take that long, because they have a chance of getting $100,000. And just think, if this client did not come to us, they would be making payments on $100,000 with interest that would continue to grow, year after year after year. So knowing this information that I'm giving you is very important. So looking at this response, there was a challenge made to the debt collection company who purchased the debt. There was a challenge made to the attorney who was representing the debt collection company to collect on the debt. Remember, with the video that I made the other day, Supreme Court states that a debt collection attorney if a debt collection attorney is collecting debt for a debt collection company, that they are under the Fair Debt Collection Practices Act. So you have a right to challenge everything that attorney submits under the Fair Debt Collection Practices Act, and specifically to make sure that attorney is verifying, because they could just submit all the documents that they want to submit. But what is the verification of those documents? Did they verify, and what was the means for them to be able to verify that those documents are 100% true? The next thing is, how was the amount that they claim that this gentleman owed accumulated? So any debt collection attorney is going to come to court with an amount that you owe and a few statements. But how was that amount accumulated? What is the accounting records showing how this amount was accumulated? You have a right to get that information. The next thing is showing and making them prove how they actually got the debt, the bill of sale, and showing the specific account numbers for that on that bill of sale for that particular account. Can they provide you those documents, and did the attorney review those documents to make sure that the account that they're claiming was included in the portfolio? Did the attorney look that over? The next thing is, in any portfolio that these debt collectors are buying, were there any deficiencies or errors in those portfolios? When reviewing the bill of sale documents, I would say in 100% of them, it will state that there are no guarantees in that portfolio. Did that debt collection attorney review that portfolio to see what accounts in that portfolio, what specific accounts are not guaranteed and what specific accounts are guaranteed. Did that debt collection attorney do that? That was a challenge that was put into this response. Now, just full transparency, you have to word this in a way that, number one, the debt collection attorney will understand it and know that you know what you're talking about. And then also that the court understands in a way to make the court say, this is reasonable. This is reasonable request on the part of this defendant. This defendant is not just coming to court saying, I don't owe this money, I don't know anything about it, or I don't know what I'm going to do about it. This defendant is in court asking, did you look over these documents and can you prove and verify these documents that you're submitting to the court, because you have a responsibility as an attorney bringing these documents in the court to make sure that they're all 100% verified, including the claim amount that you say that this defendant owes. Another thing that we specifically found in this particular case was that the notice of assignment was not properly put together from the original creditor to the debt collector. And the reason why that there was a problem with this is because that went through several hands before it got to the debt collection company, who ultimately had control of the account. Whenever you see something like that, the next thing that you want to do is you want to challenge all of the companies that had their hands on those documents. And it can make your response very long. But you have a right to do this, because if it was changed, think about it this way. If a document that they're claiming is true and it was handed down from another debt collector to another debt collector, what is the verification process that was used with that debt collector? Because essentially, the debt collection company who holds the debt, if they purchased it from another debt collection company, they are essentially saying that they believe all documents that were transferred from the other debt collector are 100% true. Can they actually say that those documents are 100% true if they came from a debt collector? Yes, they can. But if you challenge it and say, you got it from a debt collector who was not the original creditor, how did that debt collector who gave you the documents, what was your verification process for those documents? And then what was the verification process for the debt collector who purchased the account from the original creditor? They don't want you to ask those types of questions. Also, specifically for credit card type accounts, you can specifically ask for any PIN codes. You can specifically ask for any signatures. You can specifically ask for anything that can prove any type of digital signature for all of the amounts that they claim that you owe. You can specifically ask for any payments that you have made so you can reconcile the amount that they claim that you owe. You can ask for all of the payments that you've ever made. You can ask for a breakdown of the interest rates that was charged. You can ask for any rewards that were supposedly paid out. You can ask for any disputes that you could have made with communications with the original creditors, that you want all of those documents to be released to you. Now, you might be saying, well, Steve, this account happened 2-3 years ago, depending on statute of limitations in your state, or even a year ago. There is a mechanism in the law called laches, and that mechanism can be utilized in your favor by stating that they brought this case so late that you don't even have access to documents, because once they transfer over to another company, and however long that company took to come after you for that debt, you don't have access to any documents directly with the original creditor. Everything is referred over to the third-party debt collection company. And so that means that they have a responsibility to provide any documents that you ask them to provide. Now, if you keep asking them to do a debt validation, they're just going to give you the documents that they have for a debt validation. What you want to do is you want to make them go on record having that attorney state how they are verifying everything about that account. And then you start that back and forth with them saying, okay, here are the statements that you gave. How did you verify this amount that you came up with on the statement? And then you look at those statements and you see, does that reconcile with what they're even claiming that you owe? Like the gentleman stated in the email, he knows that it was about $2,000, but they sent the lawsuit for $4,000. How did they come up with the $4,000? What accounting are they looking at to come up with it, or are they just looking at one statement? And then if they're just looking at one statement that has one amount on there, get you all of the statements to backtrack to see how they came up with that amount and see if they could prove that with the documentation. And then also to see if the attorney is willing to sign off on the documentation that they're claiming that adds up to be that amount. And how is that attorney determining that that amount is true? And that's not even going into all of the other stuff that they have to do. They have to give you a conformity statement that shows that all of the documents that the portfolio that they purchased with those accounts conform to the way that the law specifies it has to be transferred. Those documents cannot just be handed from one debt collection company to another debt collection company. There is a conformity statement that must accompany any lawsuit that a debt collector is bringing, because that conformity is actually showing that there was some sort of paperwork that was verified. But here's the catch, is that it is not specifically stating that everything was verified 100% true. It's just stating that one company sold it to another company, and this is the document. And actually, when I look at those documents are made to make the court feel comfortable with allowing the process to continue. Just like I've seen these affidavits that were put together by individuals that work for the debt collection company stating, I'm familiar with the accounting records and the books and all of this stuff, and they're not familiar with working with the company that they purchased the debt from. They're familiar with getting the debt, putting it on their books and saying that this is the amount that someone owes. They put it in an affidavit, and then they put that in the court, the lawsuit with the court, with the summons. And it makes the court get comfortable saying, oh, okay, someone familiar is putting an affidavit on file swearing that they're familiar, and it makes it look like the debt is more valid. When it has absolutely, I won't say it has absolutely nothing to do with the case, but it has nothing to do with verifying the documents from the original creditor. It only has a verification that the documents were transferred with an amount and whatever statements and stuff that they included with that. That's all it verifies. It does not verify that an attorney has looked at it to make sure that all of the documents are true. Does not verify that an attorney knows that the claimed amount is true. It does not verify none of that stuff, but it makes it look like it verifies it. Another thing that I want to say is that debt collectors are not going to just give up on stuff unless you put it flat in their face in a way that they feel that, hey, we have to just dismiss this case, because they will run it up all the way as far as they can go. One of the ways that they try to run it up to get, it's like, I call it like the last trap, the last gasp, is that they will ask you to produce productions and admissions. They're going to also discovery. This is information that they want you to produce to get ready for trial, because they want to know what all you're going to say in your case if it ends up going to trial. I call this the trap documents, where they try to trap you. They try to get you to give them the information to be able to make it easy for them to prove that you have to pay the alleged debt that they're claiming that you owe. They try to take all of the what's the right word for it? Take everybody off of looking at them and have everybody just looking at you. When really it should be the other way around, because they're the one that's bringing the case. They're the one that have to prove everything. You don't have to prove anything for them. And so they'll send out that discovery, production, and admission, and interrogatories for you to fill out. And there's a specific way that you have to fill those out, or you will entrap yourself. And I think that you would do yourself some good if you would do some research about what you do and don't have to do when they are requesting that you fill out those interrogatories and production and admissions, because you do have rights. Some stuff you're going to have to answer, some stuff you don't have to answer. But if you start off the process right by making sure that your response to the debt collection attorney and the debt collection company is put together in a way that gets them thinking that this is not going to be dealing with an ordinary individual that doesn't know what to say, doesn't know how to say it, doesn't know how to construct it, that if you start off right there, most of these debt collection companies will just dismiss the case outright. They would just dismiss it. But if you just say that you don't admit to anything, you want them to just prove it, and you don't put it in some form or fashion to get them and the court to think about what you want them to prove, you're going to lose your case. You're going to lose your case. So if you have debt collection companies either suing you in court or sending you debt collection letters, you can go to my website, thecreditrepairshop.com, in the live chat, upload your document so we can review it, and we'll tell you how we can help you or how you can help yourself. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early in the game, grab my 3-pack of letters. Statute of limitations letter, debt validation letter, cease and desist collection activities letter. I do ask for a donation with those that can save you time, money, and frustration. Thank you for your time. Please like this video. Please subscribe to the channel. Post your questions and comments. I'll be in there answering as many as possible. Links are below this video for all services that we provide. Thank you for your time. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.